Guys, I am very, very cold this morning. Not as cold as Judy, though. 18 below. Yikes. It's 36 here. And I have no heat. I only have a space here. I'm wearing my husband's clothes. I'm cold. Oh my goodness. I just watched there's this guy, I think his name's Matthew Penner. And I don't know what state in the South he's from, but he's from the South and he does all these funny videos about Southerners. And I just watched, he did one um, about Southerners when it gets this cold. And he said something in there that I've been saying for like 2 weeks now. And it cracked me up because I didn't think of it as like stereotypical something Southerners said. Now I'm kind of embarrassed that I've been saying it for 2 weeks. If it's gonna be this cold, it should snow. We should be allowed to have snow if it's gonna be this cold. Now I feel stupid for saying that. But dang it, if we have to suffer through all this cold, we should at least get snow. Anyway, they're in the courtroom. Jason Chen is in the courtroom, but they're just sitting there. I don't know what they're waiting for. The sound is off. They're just sitting there looking at each other. I guess they're waiting for the jury. So we went to Manatee Springs Park and had our pictures taken by my stepdaughter's best friend, who is a professional photographer. And we don't have the pictures back yet, but I have gone swimming at Manatee State Park since I was a teenager. I've never seen a manatee there until yesterday.
Do you swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, Jason. You have the choice today of whether to testify or not testify. Is after talking with your attorney and going through your own thoughts, what is your decision of whether or not you want to testify?
Not to testify.
She's not the testify.
Yes, sir.
That's why I just want to talk a little about how you talk about it with him, talk over with him.
Yes. So, Jason, we've met a number of times. We've talked about what your testimony would be, and you understand that even though you might have an opportunity to say your piece, that you would be subject to cross-examination. And I've explained to you that the cross-examination would probably be very intense and relentless. And by subjecting yourself to that, you can change the status of your case. You can make it worse. You can make it better. That's the thing about testifying. You don't know how it's going to go. But it's important that you understand that you have an absolute right under the Fifth Amendment to testify. In your case, no one can prevent you. The judge, the court, no one, is certainly not me, is stopping you from testifying. This has to be a personal choice. On the other hand, if you want to testify, there's nothing this court would stop you from doing that. So whatever it is that your decision is, it is a personal decision that only you can make. Have you had enough time to consult with me, talk about whether or not, go over the benefits and detriments of testifying?
Yes.
Are you deciding not to testify on your own volition?
Yes.
And that's what your personal decision is?
Yes.
Jason, also, Tennessee law requires that the jury fix
Okay.
any fine greater than $50. You have the ability to waive that right and allow this court, Judge Patterson, to decide the amount of any fine, if any. We've gone over the benefits of allowing the court to decide versus the jury to decide. We've given you these recommendations. Do you want to waive your right to have the jury assess fines in this case?
Yes.
Mr. Chen, Mr. Weiss is a thorough attorney. I know he's gone over this with you before. He's obviously been over with you just in podium. I just need to make sure to understand everything that you obviously consulted Mr. Weiss and Mr. Morrison, but it is your constitutional right to testify. We're not testifying. If you were to testify, you would be cross-examined by the state. However, while your attorneys can give you advice about their opinion, whether it's a good thing to testify or not testify, ultimately that is your decision. So your attorney asked you this, but now I'm asking. All that being said, it being your call and your constitutional right to testify or not testify, what is your decision?
Not to testify.
So you executed this waiver.
Yes, sir.
And as Mr. Weiss indicated that the jury does get to set fines over $50. Most people waive that. I see you sign a waiver here for having the jury set the fine, and you're allowing the court to set that fine, if any, correct?
Yes, sir.
Thank you, Mr. Counsel.
Hey, Nancy. No, I'm not sick. I think it's just my sinuses.
All right, so procedure will bring the jury in. I'll ask the defense if any more proof.
No.
From the
Nancy,
defense.
I mean, not Nancy,
I'll
Judy.
ask the
I have never been, I've been to Crystal River, but I've never been like in the water where the manatees are. This time of year when it's cold is the best time to go because, and that's probably why I saw one yesterday, because the water's warm up in the springs. It's 72 degrees, and that's where they go in the winter, up into the warm springs. The only thing is, because of the Marine Mammal Act, you can't be in the water with them. You can be in like a boat or a canoe or a kayak or whatever, but you can't physically be in the water. I was swimming at another state park one time, and they had a lifeguard, and the lifeguard started screaming at everybody, "Get out of the water, get out of the water." We couldn't even physically be in the water while there was a manatee there. But I don't know if you guys can make out the manatee. He never breached the water. He stayed underneath.
Good morning, jurors.
But I was like,
We had an enjoyable day at R&R yesterday, as much as you can enjoy it.
forget taking pictures. I'm more excited about the manatee.
Didn't have too much fun Saturday night, I hope. No? Okay. All right. We'll start as always, just asking to make sure that you make sure everyone was able to abide by the court's admonition not to be exposed to media, not to talk about the case among yourselves. One of the other things the court admonished is that correct? If so, just nod your head. Get the record reflect everyone's nodding their head. Okay. All right, Mr. Weiss. Any more witnesses for the defense?
The defense, Russ.
State calling you rebuttal witnesses.
No, Your Honor.
Ladies and gentlemen, you've heard all the proof you're going to hear in this case. What that means is that there are some matters we do need to take up apostolic presence. It may take a little bit of time. I'm not sure how long this will go. However, once that is settled, you'll be brought back in. The court will read to you jury instructions, the thick packet. You don't have to write down what I say, just pay attention because you'll have a copy to refer to later. So many points that both sides want to point out. Once I read the majority of the jury instructions, both sides will have a chance to do their closing statements. The state will close first. The defense will do a closing argument, and the state wishes they have a chance to do a rebuttal argument. At that point, we'll finish the jury instructions. We'll pick the alternates, and there's a little special way we'll do that. And the 12 of you who are selected to be the actual jury in this case will go back to jury and deliberate. So that's what's ahead of you. Again, I'm not sure how long it'll be. We'll bring you back out, maybe a short amount of time, may not be. Be patient with us, and we'll get you back out as soon as we can. That's the next step in the jury.
When it snows in Florida, it melts as soon as it hits the ground. It snowed in Florida 3 times in my lifetime. And it just, it doesn't even stick at all. It's gone. Now when it hits objects that aren't warm, it stays for a little while. I remember
I think you have to want to make a renewed motion.
it laid on our a picnic table in our backyard, and my mom made a snowball and put it in the freezer. I'm like, Mom, what are you doing?
Pursuant to Rule 29 of Tennessee Legislature Procedure, the defense moves for judgment of acquittal, renewing it for the same reasons and in the motion the defense made after the state rest.
Okay. I don't believe the witnesses called by the defense tipped the balance to the degree where, looking at the evidence, the light most favorable to the state, that any rational finder of fact could not find the element of the offense. Again, this isn't a finding of guilt beyond a reasonable doubt. It's simply a finding that allows the case to be sent to the jury. So, twice your motion respectively. Okay, I see a motion to exclude voluntary manslaughter.
Yes, Your Honor, would you like to take the argument at this time?
Is it not a lesser?
It is a lesser if the court finds that evidence exists which could cause a reasonable juror, based on the proof presented. We would start, Judge, with Tennessee Code annotated 40-110,
Wow.
which
I know what you're talking about.
Trial judge shall not instruct the jury as to any lesser.
I know exactly what you're talking about,
unless the judge
Judy.
determines that the record contains any evidence which reasonable minds could accept as the lesser included offense. Further, the state has included many cases of first-degree premeditated murder in which the trial courts excluded as a lesser included offense voluntary manslaughter. The case law is very, very clear on this, Judge. A murder will only be reduced to voluntary manslaughter when the provocation was caused by the victim. Adequate provocation is an element of voluntary manslaughter, as is state of passion. The defense has put on zero proof of state of passion, or more importantly, adequate provocation by the victim. Pieces of glass of the nature that the jury saw underneath the futon are not any type of proof of adequate provocation. A witness who heard a female scream in, quote, distress 7 minutes before the location was sent to Katrina Bean is not evidence of adequate provocation. The jury instructions, simply according to the law, should not be given to this jury. They have no evidence, no proof whatsoever of adequate provocation. The cases are interesting. The cases are similar. The courts in each case, when there was some type of argument, in fact, Judge, the cases, in all cases, there is proof of arguments. There is proof of passion, even in some of our cases. But the courts found that adequate provocation by the victim is required and was not found in cases with actual arguments. There has been no proof in this case of an argument. There has been zero proof of even an argument in this case. A much lower threshold than what courts have found in the cases that the state cites. And the reason this was not proper, Judge, is because the state had to be brought before today, is because the state had to wait for the defense to rest. The state didn't.
I get it. I hope you know I was just trying to be lighthearted.
Sure. Well,
And then
but,
comment earlier.
yeah, but procedurally, I hope that all parties understand why this couldn't be raised. But it's the law. And so it can be a lesser included, as the court asked, but it is not a right of the defendant to have this instruction given by the court. We would ask that it be excluded based on the law, Judge.
That's one point here. I mean, I don't want to hear from Mr. Weiss, but I can tell you that the threshold to charge an offense, the jury instruction, is less than a preponderance. It's not much at all. And like the motion earlier about the judgment of acquittal, this one is taken in favor, like most favorable to the defendant. What I recall, and I'll let Mr. Weiss, fill in the gaps if I missed anything. Clearly, they were in a relationship, which doesn't by itself, mean adequate provocation. But the fact that there was some type of fight, whether as the state was basically not contributing to it at all, there was some type of fight between two people who were in a domestic relationship of some kind. And if I recall Dr. Cogswell's testimony, when Mr. Weiss was cross-examining him, the testimony about the knife being held in the same position, I think Dr. Cogswell indicated that it would have come very fast, without much movement, on the part of the defendant. And I believe the language that Mr. Weiss got out of him was either heat of passion or heat of excitement. So that's what I would recall. If you want to respond to that, you can now. If you want to wait for Mr. Weiss to let you know.
Well, heat of passion is not mutually exclusive with premeditation. Most first-degree murders involve passion to some extent, right? And so, in our cases like this, I don't believe that even if you give Mr. Weiss the benefit of the doubt and say, there was proof of an argument, according to Tennessee case law, that's not enough for adequate provocation. There was also proof introduced that there was chasing from the bedroom of the apartment to the front door. I think that could negate any type of argument that it was a heat of passion where there was an argument going on. I think that could indicate to a reasonable juror that she was trying to run away, right? And so I don't believe the proof on the record supports any type of adequate provocation, Judge. Even Dr. Cogswell's testimony. Often in first-degree cases, gunshots are fired back to back to back to back. I don't think it matters that the stabs happen. If the stabs happen 1 second after 1 second, you still have 60 seconds of stab wounds. So respectfully, the state will always trust the sound discretion of the court, but respectfully, I believe that the law supports no instruction on voluntary manslaughter.
Thank you.
Firstly, Your Honor, this looks like a well-written motion, and it's been written for some time. If the court knows my modus operandi, I would love to be able to go through this with a fine-tooth comb and shepherdize each case and look at any subsequent case law on it, and also search for case law that would provide perhaps the opposite conclusion if it existed. I doubt I have time.
We'll say this. Of course, I can make a ruling on this after you argue. You don't have to sit down and after looking at this and trusting with the whole case, the essence of the case is in the state's motion. I'd love to hear your argument, but we'll take a break and give you some time to look at it if you wish.
Even if I can't do an adequate job in 5 or 10 minutes.
I'm saying if you want to take, again, this is important enough where if we're closing today, I want to give you as much time as possible. I want to give you as much time as possible under the circumstances. So we could break till about 10:30, give you a chance to look at some of these cases. If you get into it and decide you need some more time, we certainly will.
Yes, Your Honor. Would the state be courteous enough to send me a digital copy of this?
Of course.
Yeah, I appreciate it.
We'll
Thank
send
you.
it to you and this one.
Okay, so the court will be in recess till 10:30, and Mr. Weiss, you get your answers sooner or later, please let me know.
Are the other motion for jury instructions from the defendant later or at this time as well?
We'll do it that time. We'll take it one step at a time. Consider additional instructions the state wishes.
Oh, no, Your Honor, the defense filed a motion for additional instructions.
Okay, I'll look at that.
Okay, thank you, Judge.
So I can copy it.
Okay. I was looking up something. So why are we in recess until 10:30? Judy, is it the Crystal River Energy Complex? The nuclear plant is being decommissioned. They started in 2006. It says it's going to take like 30 years to decommission it safely. But yeah, the manatees go they go up into, well, there specifically because of the electric plant, and up into the springs because the water's warmer there. It is a recess every 10 minutes, Rao. It's crazy. It's driving me nuts. And there's a lot of places in Crystal River that do tours with kayaks and canoes and that kind of thing, where you're close to the water, but you're not physically in the water. And if you come around, and I don't think you can do it by yourself. I don't think you can just take a boat and go into these areas. I think you have to go by with a guide because there's specific rules. Like you can't do anything that's considered harassing the manatees. There's like strict rules you have to follow because they're endangered. I don't know if they're still endangered, actually. I know they were at one time, but there's still that Marine Mammals Protection Act. But there's all kinds of tours and stuff that you can take to go down the Crystal River and see the manatees. But like I said, I've seen 2 in the wild. I saw, it was the one that actually swam up into the springs. We were at Fanning Springs, which is another spring off of the Swanee River. And like I said, we were in the water and the lifeguard was, get out of the water, get out of the water. Manatee Springs, there's not a lifeguard there. And of course, nobody was swimming because it was cold yesterday. That one was actually in the summer when it was hot and people were swimming. So it was like, it's not normal for them to come up into the springs. No. Are you talking about Steve Irwin? No. The manatees, they're sea cows. They're gentle. They won't mess with you or anything. They just kind of bob around in the water. Spike. That's the manatee. That's that big flat, that's his tail. And the round part is his body. So he's like facing away from me. Yeah. No, I think you're thinking manta ray, not manatee. And it was raining and overcast. But the sun did finally decide to come out a little bit. That's the Swanee River. So we walked. There's a dock or like a boardwalk thing that you can walk from the springs out to the river. So we were out there taking pictures. So let me. So this is like Kristen sent me this. This is she said it's the first sneak peek of the pictures. So here's one of them. So you see the river behind her. That's Kristen. That's my stepdaughter. That's the only picture I've seen so far. But that's why we took him there to get the river background. And here's Travis and the girls. And Kristen's in black and Casey's in red, and then that's Travis. And yes, I'm wearing the same shirt that he wore yesterday today. I was like, "Did you get it dirty?" He's like, "No." I'm like, "Good, because I'm going to wear it tomorrow." He goes, "Man, you lost weight, and now you're going to wear all my clothes." I was like, "Yeah." Well, I scrapbook, so anytime we do anything together, I take pictures too. So, and I didn't take pictures at first, and then it dawned on me I should be taking pictures of them taking pictures. So I did get some in at the last minute, but I'm glad I got those pictures of the manatee. I love manatees; they are cute. They're like they call them sea cows, but to me, they're more like dogs of the sea. Their faces are cute. They're adorable. That is what, I mean, this is what they say. I don't see how, but supposedly that's what sailors saw back in the day that they thought were mermaids. I don't see how you can confuse that with a woman with a tail. Unless they just been out on the sea for so long that anything looked good to them. I don't know. But I don't know how you... Let me see. I don't know, when I showed you guys the picture from Manatee Springs the other day, I don't know if it had a good picture of a manatee or not. I learned to scuba dive here. $800-foot boardwalk. I walked 800 feet yesterday. Well, twice. Oh, yeah. You can't. You can't bring in outside firewood, because there's I guess a bug that infests wood, and if it's in firewood you bring in, you can infest our Spike. Oh, really? I don't know. I've never looked at a manatee's nether bits. So I don't know. Ah. Spike, I am not in the mood for this today. I want to see a picture of their face. Where are the manatees? That's where I learned to scuba dive. And that's the boardwalk that I walked yesterday. I didn't realize I was 800 feet. Well, that's not a real manatee. That's the little. I have pictures of the girls when they were little playing on that manatee. Well, teenagers, not little girls, but. Well, where are pictures of manatees? Yay! I'm back. Thank Jesus. I thought I was going to miss everything today. And then I call my ISP and I get a recording. We are not experiencing any outages. Well, guess what? You are. You just don't know it. Now I got to find the trial again. 17 days, y'all. 17 days. And they're still not there. And everybody left me. I told y'all not to go anywhere. Now I need to get my channel up so I can see what you see. I told my stepdaughter, I was like, dang it, I gotta work. I got that trial to do tomorrow. I'm not gonna get to see the inauguration. She goes, we have 2 screens, just put one on the other screen and mute it. And no, I can't do that. I cannot multitask like that. If I am watching a trial, I multitask with the ADHD, but the problem is I can't as it's like I can do more than one thing at a time, but I can't totally concentrate, and like I can divide, but I divide my concentration too, so that I don't have like 100% concentration, and then it ends up being crap. Whatever I'm trying to do, if I try to do more than one at a time, it ends up being crap. Basically. Joy Reid collapses on air during drunken Trump rant. I'm so tired of these people finding joy in other people's misery. Well, is that what we do, though? That's kind of what we do, huh? We're not finding joy in it. We're out for justice. Justice for the people that are wrongly killed. I love chickpeas. There's a vegan chickpea cheesecake. Now, I don't care about vegan or not, but it looks just like cheesecake. I wonder if it tastes like cheesecake. I doubt it. I still want to try it though. Because chickpeas are protein. Well, so is cream cheese, but it's got sugar in it. Oh, that's why they did a recess. I totally missed that. So on the News Channel 9, it says defense rests. Did you hear him say defense rests? I didn't hear him say defense rests. I thought they were going to rest on Wednesday. So good. They're going to bring them back in and read them jury instructions, and they're going to go out and deliberate. I might still get to see the inauguration. Yay! Do you guys want to watch the inauguration? I can stream it. I mean, I don't do political stuff, but I mean, it's the inauguration of the president. That's up to y'all. Let me know. Some Scottish people can't say purple burglar alarm. What? I don't have any Scottish viewers, or I would ask y'all if you can say purple burglar alarm. What? Good Lord. Texas cheerleader accused of poisoning rival's show goat, barred from caring for her pets on her own. Who poisoned a goat? Oh, okay. So the judge is deciding whether he wants to remove the lesser included charge. That was his whole defense, though. I didn't think they could remove something that was your whole defense. I thought that, because like, wasn't that a thing in Sarah Boone's trial that she was entitled to the defense of battered wife syndrome? Because like when the state wanted to like get rid of her, the expert witness, in that what Owens argued was that she was entitled to that defense. No, I just don't understand people anymore. You know, they don't teach kids nowadays to respect other people and property, and to like that. She poisoned a show goat. Like, and if you don't know what a show goat is, when you live in rural places like I do, they have livestock fairs. Yeah, I heard that part. So we have livestock fairs. When I was in high school, we would get out of school like three or 4 days the week of. Might even been the whole week. I don't remember. Because people had show goats and pigs or hogs, cows that they would sell. And they would get like so much a pound for the ones that was sold for food. And I didn't have, and the chicken, whatever, livestock type stuff. I entered things into like the home ec type things, like cross stitch pictures, and I would draw stuff, or I would make a baked good. Like that was my thing. I didn't do the animals. But we would get out of school for that. That was like school holiday because we had our big livestock fair. But when I was, even when my goddaughter was little in the 90s, there was no like participation things where nobody won or lost. It was just, you played and you had fun. It was one side won, one side lost. And you learned that that's the way life was. You played a game, one side wins and one side loses, and that's the way it was. And then as I got older, I didn't have kids, so started hearing about this. Oh, you just get like a participation trophy. Nobody wins, nobody loses. And I think that is part of the problem why society is the way it is today. And we watch those videos on Biggin And everybody always says, this person was never told no as a child. And I think that's probably true, probably partially true. If you don't ever tell a kid no, if you don't teach a kid that life is not fair, if you don't teach them that it's not always going to go your way, there are going to be times where you're going to lose and you're going to have to step back and say yes sir, no sir, and just toe the line. If you don't teach them that, they're not going to have a very good chance in life. They're always going to be in trouble. And I tried to teach my stepdaughter that when she went into nursing school. Because I went through nursing school twice. I went to LPN school and then I went to RN school. Hardest thing I've ever had to do, aside from having cancer, but hardest thing I've ever had to do in my life. And I told her, you're just going to have to smile and nod. That's the thing that we started saying to each other in nursing school. Smile and nod. Smile and nod. Don't argue back. Just do what they say. No matter how ridiculous, how stupid, how whatever. No matter what you think about it, you got to do it their way. When you get out in the real world, they'll teach you shortcuts and stuff to do it however. But while you're in nursing school, she flunked out the first semester. And she would get mad every time I would say to her, you just got to smile and nod. You got to do what they say. Just keep your mouth shut and do what they say. And she flunked out the first semester. She said it was because of her test taking, which could be true because she has test anxiety. So that's possible, but still. So younger generation, they talk back to authority now, and I don't get it. And I wonder if it's because I was raised by a cop and always taught to respect authority. I don't know. I don't know if it's the way I was raised, or if it's my generation. I don't know. But I see these people just like ignoring authority, and I'm like, why? What is your problem? It doesn't make any sense. Talk to me. Anyway. Who poisoned a goat so they can win a goat competition? Or maybe not. Maybe it said she was a cheerleader. So maybe it was a rival cheerleader and she just wanted to poison her goat because she hated her. I don't know. I don't know the whole story. But I am so sick of Whoopi Goldberg. She is just all over the place. I used to love her. I still do love her on Star Trek. And her movies. I don't understand why people that are celebrities why they think that their opinion on things matter to us. That's their job. They have a job. They go to work every day just like everybody else. Why being a celebrity, why do they think that we need to know their opinion on everything else in life too? When I was a nurse, nobody cared about my political views or anything else for that matter. the brand of makeup I used or hair dye or what brand of clothes I bought. You know what I mean? Like, why do we care just because they're a celebrity? I don't understand it. Oh, cool. Congrats. Oh, that's amazing. I have an Associates of Science in Nursing. I was going to go back and get my BSN and then go into pediatric nurse practitioner. And then I got the fibromyalgia had gotten so bad that I just couldn't work anymore. And I didn't even think about switching to a less active nursing position. I didn't know what was out there. And then when I got the cancer, I saw more nursing type jobs just from being shuffled around from place to place to place to have all the, the testing and the different surgeries and the different procedures and all that because of the cancer. And I thought, what did I do? Because I don't have a license anymore. They're over, I don't know what they cost now, but back then in 2010, when I got my disability, it would have been over $100 a year to keep it up, just the license itself. And then the continuing education would have been $100, $200. And I thought, I'm on disability. I don't have a big income. Why am I going to spend $300 a year to keep up a license that I'm never going to use again? But I didn't look down the road. But still, I wonder, even though that I'm better now, I still don't know if I would be able to hold a job. Because there are days that you'd like, yeah, I can sit here and talk to you guys and stream a trial. But there are days that I get up and I just don't feel right. Like the fibromyalgia is still there. I mean, that's always going to be there no matter what else is wrong with me. And some days I might be super, super nauseous. Other days I might be super, super dizzy. Other days I might just ache all over. It's like, and then there might be days that I'm just perfectly fine. And so there's no way to gauge, like if I had a schedule that I had to be there every day or certain days, like I can't tell you, like my cousin's doctor just, the way he explained it to her is you're not reliable, which, I mean, sounds like an insult, but it's really not when you have fibromyalgia. It's there's no way to plan around fibromyalgia because you don't know when it's going to flare up and what's going to happen. So, and I was going to volunteer at the hospital to work in the NICU because they call them cuddlers. They need cuddlers for the babies because they have to stay in the neonatal ICU. So what they do, I don't know why the moms can't go in there and do it. Unless maybe the moms are too sick. I don't know. I don't know why the moms just can't go in there and do it. Or why they can't. I guess they can't take the baby out to mom because the baby's too sick. But they call them cuddlers and they want them to be skin to skin. So like you wear a shirt with buttons or whatever so you can put them on your bare chest and just rock with them. And so I was going to sign up for that. But once again, even though it's volunteer, you can't just show up and say, I'm here to volunteer. They put you on a schedule. And the girl's half-brother, when his little boy was born, they brought him over here. And I was holding him and I was rocking him and playing with him and stuff. And my shoulder blade in the back, just from holding him on my shoulder like this, hurt so bad, just rocking him like this. I was like, oh, well, there goes that idea. I can't do that because I can't and I was sitting on a bed. So, like, if it got to hurting, all I had to do was, put him down on the bed. But I can't do that. I got somebody's critically ill child in my arms and my shoulder starts to hurt. I can't do that. So that's why sometimes I get depressed and I'm just like, I'm useless. Okay, it's after 10:30. Spike, what are you doing? What? 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 Oh, oh, here, talk to him. Talk. Don't sniff it. Talk. Talk. World's most boring stream. Uh, what? What? Oh, you want me to pet you? Okay. It's warmer in the bed. It's warmer in the bed, dude. It is. Warmer under the covers. Everybody thinks somebody's talking to the floor. They think I'm crazy. They don't think you exist. They think I'm talking to the floor. Because you won't talk when I give you the microphone. They don't believe me. They think you're imaginary. Okay, I'll be right back. That dog has the shortest little legs.
Favorable to the defense, I do think that the fact that the victim and the defendant were in a relationship, that they had an argument to the degree that it woke up a neighbor downstairs, there's an argument that got physical, or I should say, there was definitely some footsteps involved during this particular passionate argument. So take the light most favorable to the defense, I think we will charge voluntary manslaughter.
Your Honor, in regards to voluntary intoxication, the court will remember that when everyone entered the Jason Chen apartment, we pointed out the ball on the desk. And so that was present throughout this entire case. That was well known. So we know that there were drugs in the apartment likely being used, or at least you can take that inference. In addition to that, there was the receipt by Ms. Pace that she had bought that day. So there could also be an inference that she, when you buy end products, I would assume that you would buy them to use them. So it is a low threshold. There is no proof that Ms. Pace or the defendant was intoxicated at the time, but that for the defendant, obviously, there was a toxicology. But for Ms. Pace, they did do toxicology, but because of the interfering substance, we don't know the THC content, if any, in this case. So that would be an inference that there was marijuana. As far as wine, there's been talk about excessively open wine bottles that weren't finished, closed wine bottles. The court here heard about glass. There was evidence that was introduced in the trial about the glass. I think that there is enough that raises enough about voluntary intoxication to include that as a jury.
You want to be heard?
Yeah, well, briefly, Judge, absolutely not. Because I have 40 bottles of wine and alcohol at my house right now does not mean that last night I was intoxicated. That's a silly argument, and there was no evidence of actual drugs in Mr. Chen's apartment. There was evidence of a bong. There was also evidence presented by multiple witnesses that the apartment had no smell of marijuana. The standard is not that you show that there was alcohol in a bong in a house. The standard would be that you show with sufficient proof that either party, but this would be arguing that Mr. Chen was intoxicated at the time of the offense. There has been absolutely zero proof of that. There was proof that the victim had no wine in her system at the time of the offense. Dr. Coswell testified that it should have still been in her system by the time the medical examiner's office took her blood, and cannabinoids actually had been tested and came back with a negative result according to Dr. Coswell. This does not meet the standard in any way, shape, or form of voluntary intoxication. In fact, under this argument, in every single case of murder where there was alcohol or bong in a house, then we've got a good argument for voluntary intoxication. That's not the standard.
All right, on this one, the court doesn't find that there was evidence of any intoxication, by either party, much less by the defendant. So I think that as low as the standard is to charge voluntary intoxication, there's such a paucity of evidence in this particular situation, the court's not going to charge voluntary intoxication.
In regards to self-defense, so first I'm sorry, with the opening, there is an argument that could have been made that the defendant acted in self-defense. The defense's theory, however, is that the defendant overreacted and reacted excessively. And so self-defense isn't proper in this case. However, it is the province of the jury to decide whether or not that was self-defense. The jury could think that the defense is wrong and that he didn't have a duty to retreat. He didn't have, and he didn't overreact. They could, however unlikely, could think that. They could think the defense's theory is wrong. As far as the proof at trial, Dr. Coswell talked about the contusion on the side of his face, which is corroborative of the defense's opening, that he kicked her and she fell back. It is something happens in the kitchen, living room area, but it ends up in the bedroom. How they get back there and all those different things, if the proof that came into the trial could show, or I'm sorry, the proof that did come to trial could lead a reasonable juror to believe that Mr. Chen was acting in self-defense first, and then we were after the
Take one first.
Your Honor, the defense just said, quote, self-defense isn't proper in this case, wanting to open the statement. Mr. White really warned of the law in the state of Tennessee, and further, the idea that there's evidence that Mr. Chen kicked Ms. Pace is only evidence of further abuse, and it's not evidence of any type of self-defense. And so the state, again, would ask that self-defense is a higher standard than voluntary manslaughter when it comes to adequate provocation. There has been no proof presented by the state or the defense that Mr. Chen could have or did act in self. It is not deserving of instruction.
Right, on this particular issue, what we do have is that the defendant, I believe, is 6'1", you know, large individual. The victim's size is barely 5 feet, around 100 pounds. The only evidence of anyone having a deadly weapon is the defendant. There's no evidence that the defendant was put in a reasonable state of fear where he could have believed that self-defense would have been justified. So I don't think that self-defense has been fairly raised by the proof of court, but the request for self-defense instruction be denied.
Sure.
Okay. It is 15 to 11. A couple ways we can do this. I'd like to go ahead and need to prepare the charges. I did, as the parties know, I did have self-defense voluntary provocation in there for which they would bring. I need to tweak jury instructions. I'd like to go ahead and charge them. It'll probably take us to 11:40-ish, 11:50-ish, I would think. We can take a lunch break, come back and close at that point, or just go straight to closing that.
Your Honor, the state would prefer that the court instruct the jury and then closing arguments be after lunch back to back. I would prefer that closing arguments not be split up. I don't think that's the best way to do it. And also in terms of jury instructions, there's a blank when it's the abuse of corpse instruction. There's a blank for that second prong that includes disposing of a body in a way that's in violation of Tennessee Code annotated and then it's blank. We would argue that that would be under TCA 39-14-505, which is aggravated criminal littering. It makes it aggravated if the littering, the matter of littering is over 10 pounds.
That makes it sound like he disposed of her as like
It's gonna happen
garbage.
So that require.
I mean, which he did, but
Aggravated littering, so I can find out if it's in violation of it.
I think our jury instructions do contemplate the elements of the predicate offense to be instructed.
All right, let me tweak these instructions. Court will be in recess until that's done. I'm not sure when it'll be, hopefully next 15 or 20 minutes. I'll give the parties a copy before we bring up.
Thank you, Judge.
Thank you.
so today is just going to be a day of recesses, joy. Well, you guys, what do you? If they don't include any lesser charges, this whole trial has just been a waste of taxpayer money. I mean, I still think it's a waste of taxpayer money. Because I don't care what you say, what provocation she may have caused, 60 times is not self-defense, is not voluntary manslaughter. It's not any of the things you can defend. That's just wanting to do it. Found out yesterday that my stepdaughter is going to get to meet the president. I'm so jealous. Her niece is going to Washington, D.C. in the summer with safety patrol, which is something I never did because our school didn't have a safety patrol. I've never been to Washington, D.C. I've always wanted to go. And Casey is going with her niece. And it's going to be like $1,000, everything included. Like the little tour thing they go on, the White House tour, meeting the president, going to the Smithsonian and the Capitol building and all of that, $1,000. I was like, dang, I want to go. I'm jealous. I love museums. The thing, and I love history. And Travis, he's okay in a museum, but like I want to stop and read every plaque and like totally immerse myself. Hey, Toxic. I want to like totally immerse myself in the history, read every plaque, read everything, know everything about the exhibit. And Travis just wants to like glance at stuff and get out of there as soon as he can. When the girls were teenagers, we took them to the Natural History Museum at the University of Florida. And he was so good. He let us stay in there for hours and hours and hours without complaining. Of course, this was back when we were very first married. That might be different today. I told him for my birthday I wanted to go because we've got our museum. It's the Florida Natural History Museum. It's run by the University of Florida, and the building looks teeny tiny from the outside, but on the inside, it's like a maze in there, so they can hold a lot more. And it's free unless there's some kind of a special exhibit inside, and there's a butterfly rainforest. It's there all the time, and it costs extra to go into. And I've never been in the butterfly rainforest. So I told Travis that I wanted to do that this year for my birthday. And then it was so cold, I was like, no, I changed my mind. And I also figured the butterflies aren't going to be fluttering around. Yep. Yes, we do. Casey was telling me, my stepdaughter Casey was telling me last night, everybody's freaking out over TikTok, but that Trump was supposed to fix it so we could still have TikTok. But I don't have TikTok, so I don't care either way. But I do realize that some people make awful lot of money using TikTok. I guess I'd feel the same way if it was YouTube. I love butterflies too, and I really want to go see them. When we were there, when we took the girls, I think it was when we took the girls, because I've been there more than once. Um, we watched, what they do is like the butterflies that have died, they they like pin them to a board, and we watched this guy take this one and carefully like unfurl the wings and everything to like pin it on this board. And the painstaking process they go through to not damage this butterfly that had died so they can preserve it on this board for everybody to see was amazing. It took so long and so much patience on this guy's part. I was like, that is a job I could not do. And then we also stood there and watched one come out of the cocoon. Of course, not. It had already started when it came out because it takes, I guess it takes, I don't know how long it takes. but more time than we had to stand there. But that was pretty cool too. But we didn't go in the butterfly rainforest that day. I've never been inside of it. I've seen pictures. You can go to the Florida Museum website and see pictures of it. I would show you, but the last time I did that with Manatee Springs, it crashed everything. And it made my computer think I had no internet. I'm getting hot now. I'm going to take this flannel shirt off. I made Travis buy this shirt because I thought it was cool looking. It's got a hoodie. It's a flannel shirt with a hoodie. And then when he put it on yesterday, he's like, "Oh, cool! The pocket's big enough to put your phone in and button it so it won't fall out." He loves. Okay, when we started dating, he smoked, and he kept his cigarettes in his front pocket. So now, even though he doesn't smoke anymore, it is a habit. He wants a front pocket. He wants a front pocket on his shirt, even though he doesn't smoke anymore. And he puts his phone in there, and every time he leans forward, his phone falls out of his pocket. TikTok was banned by the Supreme Court, and I think, I can't remember if it was yesterday or today that they took it down. So TikTok is no more. But Trump said that he was going to get it reinstated. So, but this is my husband's new shirt that I made him buy. It's a flannel shirt with a hoodie. I was like, get that shirt. That's a cool looking shirt. I like that shirt. But it's hot. Oh, I have to cover the lawn crime. See, I had it like that, and law and crime was covered, but then I made my picture because I Okay. I think we're back. Maybe. That was not my fault. That was my ISP's fault. $17 days, guys. 17 days. $17 is gonna be like lightning. Oh man. Figure. Hearing Reed's hearing. If they do that Daubert hearing for Green, it's on February 6th. And that's when I get my new internet, which means my internet will be down briefly on that day. Oh well. I will stream it. I promise you I will stream it. Come on, any day now. I hate waiting. I think that's an ADHD thing, isn't it? Now, oddly enough, when I go to a theme park, I don't mind waiting in line. I mean, I don't like to wait in line. Nobody likes to wait.
I believe all the references to defendant testifying taken out, references to the aspect you already talked about.
Your Honor, do you want to bring the defendant up?
Yes, absolutely. Thank you. Grant motion.
He wasn't allowed to sit up with the
Some tweaks by either side.
attorneys?
No, I didn't realize, this makes sense, but I didn't realize that, I guess reckless homicide comes after act assault just because it's lesser.
felony of criminally negligent homicide is down there too.
Yeah, that's interesting. I've never noticed that.
Both sides, if you want to go straight to the abuse of court, you certainly can. Again, I think the references to, again, the defendant testifying was the last thing I wasn't sure about. That's been modified to show that he hasn't testified, and the jury can't hold anything against him for that. So once the parties finish reviewing it.
Well, we already knew he wasn't going to testify. Do they have to do that? Is that like a formality that has to be on the record like that? Because we knew at the beginning he wasn't going to testify. I put that in my description. They could have sought the death penalty and they didn't. Which, I don't know why. 60 stab wounds seems like a death penalty case to me.
Your Honor, with the impeachment of a witness, there, I think there might be the beginning of a sentence that might have been deleted, that's not on there.
What page you looking at?
There's no page number, it's just impeachment of the witness. There's 3 paragraphs, the last paragraph, it starts off with impeach.
Thank you. When the testimony of the witness is impeached, comma, the jury has the right to disregard.
Oh, yeah. Your Honor, there's also an instruction for a prior statement of defendant.
I kept that because wasn't there testimony about when Ms. Pace, Katrina Pace, was talking to police officers, they said that he gave statements that were.
There was also the written statements that were collected and all that.
Okay.
That's a good one.
side ready to proceed?
Yes, Your Honor.
Bring the jury in when they're ready, please. All right, please be seated. Ladies and gentlemen, I'm about to read final jury instructions. Please pay attention, you don't have to write them down. You will all have a copy. So we'll get at least one, probably several copies back to the jury and actually deliberate. But pay attention because the issues that are in these instructions do pertain to the issues that came out here in trial. So there may be one or two things that you see that you want to follow up with. Of course, the parties will follow up with them as well when they do their regular closings. Members of the jury, the evidence in this case has been completed. You will now be instructed as to the law applicable in the case. This covers your duties and the general rules that apply in every case. It also covers the offenses that are charged and included in the presentment and lists their elements. It includes some rules that you must use in evaluating particular testimony and evidence. Finally, it also includes the rules that you must follow during your deliberations in the jury room, and the possible verdicts that you may return.
Your Honor, I'm sorry. Are you intending for this to be scrolled?
Actually,
Didn't know. I apologize.
Yeah. thank you, gentlemen. It is your duty to carefully consider all these instructions. The order in which these instructions are given is no indication of their relative importance. Moreover, do not assume that because a particular instruction is given, it suggests anything about the facts of this case. You should not single out any one or more instructions to the exclusion of one or more others, but you should consider each instruction in light of and harmony with the others. Count 1 of presentment 315-228 charges the defendant, Jason Chen, with the offense of first-degree premeditated murder on or about November 23rd, 2022, Hamilton County, Tennessee. This charge includes the following offenses: first-degree premeditated murder, second-degree murder, voluntary manslaughter, aggravated assault, reckless homicide, reckless aggravated assault, criminally negligent homicide, assault, and reckless endangerment. Count 2, the presentment 315-228, charges the defendant, Jason Chen, with the offense of abuse of a corpse on or about November 23rd, 2022, in Hamilton County, Tennessee. This charge includes the following offense: abuse of a corpse. The presentment in this case is the formal written accusation charging the defendant with one or more crimes. It is not evidence. It does not create any inference of guilt. To presentment 315-228, the defendant, Jason Chen, pleads not guilty. The plea operates in law as a denial of every allegation of guilt contained in the presentment and every element of fact in the offenses charged in the presentment. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless from all the evidence in the case you determine beyond a reasonable doubt that the defendant is guilty of an offense charged or included in the presentment. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt. This burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt Is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt? Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. The state has the burden of proving beyond reasonable doubt all of the elements of the offense, and that the offense was committed before the presentment was found and returned on March 3rd, 2023. The state has the burden of proving by a preponderance of the evidence that an offense charged or included in the presentment was committed in Hamilton County, Tennessee. Proof by preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. The venue of an offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by preponderance of the evidence that an offense charged or included in the presentment was commenced or consummated in Hamilton County, Tennessee, you must return a verdict of not guilty. At times during the trial, the court has ruled upon the admissibility of evidence. Do not concern yourself with these rulings, either by such rulings, these instructions, or any other remarks that I've made. Do I mean to indicate any opinion as to the facts or as to what your verdict should be? Statements, arguments, and remarks of counsel are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made that you believe are not supported by the evidence, you should disregard them. You are the exclusive judges of the facts in the case. You're also the exclusive judges of the law under the direction of the court. You should apply the law to the facts in deciding this case. You should consider all the evidence in the light of your own observations and experience in life. Any person who commits the offense of first-degree premeditated murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the victim, and 2, that the defendant acted intentionally, and 3, killing was premeditated. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exist in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. The design to kill was formed with premeditation. It is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion. The accused commits the act after the passion has subsided. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant unlawfully killed the alleged victim, and 2, the defendant acted knowingly. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. In the context of this offense, the person acts knowingly when the person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. In the context of this offense, a person acts intentionally acts with a conscious objective or desire to cause the death of the alleged victim. Any person who commits voluntary manslaughter is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant unlawfully killed the alleged victim, and two, that the defendant acted intentionally or knowingly, and three, that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. In the context of this offense, a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when a person acts with an awareness that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant intentionally or knowingly caused bodily injury to another, and two, the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of circumstances surrounding or result of his or her conduct when the person is aware of the nature of the conduct, that the circumstances exist, so that the conduct is reasonably certain to cause the result. Any person who commits the offense of reckless homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant killed the alleged victim, and two, that the defendant acted recklessly. In the context of this offense, a person acts recklessly when the person is aware of, but consciously disregards, a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. In the context of this offense, a person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. Any person who commits the offense of reckless aggravated assault is guilty of a crime. When you find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant recklessly caused bodily injury to another, and two, that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct the person is aware of, but consciously disregards a substantial and unjustifiable risk that the circumstances exist, result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. Any person who commits criminally negligent homicide is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant's conduct resulted in the death of the alleged victim, and two, that the defendant acted with criminal negligence. A person acts with criminal negligence when the person ought to be aware of a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that the failure to perceive it constitutes a gross deviation from the standard of care that an ordinary person would exercise with all the circumstances as viewed from the accused person's standpoint. The requirement of criminal negligence is also established if it is shown that the defendant acted intentionally, knowingly, or recklessly. In the context of this offense, the person acts intentionally when it is the person's conscious objective or desire to cause the death of the victim. In the context of this offense, the person acts knowingly when the person is aware that his or her conduct is reasonably certain to cause the death of the alleged victim. In the context of this offense, the person acts recklessly when the person is aware of but consciously disregards a substantial and unjustifiable risk that the alleged victim will be killed. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find beyond a reasonable doubt that the defendant was criminally negligent, you must also find that the death of the alleged victim was the proximate result of the defendant's criminal negligence. Defendant's actions need not be the sole or immediate cause of death. If you find that the direct cause of death was an act of the victim or third party, before you can convict the defendant, you must also find beyond a reasonable doubt that the act of the victim or third party causing the death is a natural and probable result of the defendant's criminal negligence. Any person who commits the offense of assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally, knowingly, or recklessly caused bodily injury to another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness, or the impairment of a function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, that the conduct is reasonably certain to cause the result. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or the result of his or her conduct. And the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the person who commits the offense of reckless endangerment is guilty of a crime. You find the defendant guilty of this offense. The state must have proven beyond a reasonable doubt the existence of the following essential elements. One, that the defendant engaged in conduct which placed or might have placed another person in imminent danger of death or serious bodily injury. And two, that the defendant acted recklessly. The threat of death or serious bodily injury to be imminent, the person must be placed in a reasonable probability of danger as opposed to a mere possibility of danger. Before you can convict the defendant, the state must show beyond a reasonable doubt that a person or class of persons is in the zone of danger. The zone of danger is that area in which a reasonable probability exists that the defendant's conduct would place others in imminent danger of death or serious bodily injury. Serious bodily injury means bodily injury that involves a substantial risk of death, protracted unconsciousness, extreme physical pain, protracted or obvious disfigurement, or protracted loss or substantial impairment of a function of a bodily member, organ, or mental faculty. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, physical pain or temporary illness, or impairment of the function of a bodily member, organ, or mental faculty. In the context of this offense, a person acts recklessly with respect to circumstances surrounding the conduct or result of his or her conduct the person is aware of, consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. The requirement of recklessness is also established if it is shown that the defendant acted intentionally or knowingly. In the context of this offense, a person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. In the context of this offense, a person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, that the circumstances exist, or that the conduct is reasonably certain to cause the result. Any person who commits the offense of abuse of a corpse is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1A, that the defendant physically mistreated a corpse in a manner offensive to the sensibilities of an ordinary person, or B, that the defendant disposed of a corpse in a manner known to be in violation of Tennessee Code Annotated 39-14-505, which defines the offense of aggravated criminal littering as littering in amount exceeding 10 pounds in weight or 15 cubic feet in volume, and that the defendant acted without legal privilege, and that the defendant acted knowingly. In deciding whether the act was offensive to the sensibilities of an ordinary person, the jury must avoid subjective, personal, and private views and evaluate the sensibilities of a hypothetical average adult person, applying the collective view of the adult community as a whole. Ordinary person means a person of ordinary care and diligence in relation to a particular thing. Littering means knowing, placing, dropping, throwing litter on any public or private property without permission and not immediately removing it. Litter includes garbage, refuse, rubbish, and all other waste material. Garbage includes putrescible, animal, and vegetable waste resulting from the handling, preparation, cooking, and consumption of food. Refuse includes all putrescible and non-putrescible solid waste. Legal privilege means a particular or peculiar benefit or advantage created by law. A person acts knowingly with respect to the nature of, circumstances surrounding, or result of his or her conduct, and the person is aware of the nature of the conduct, the circumstances exist, that the conduct is reasonably certain to cause the result. The requirement of knowledge is also established if it is shown that the defendant acted intentionally. A A person acts intentionally with respect to the nature or result of his or her conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Before the defendant can be convicted of any degree of homicide, the state must have proven beyond a reasonable doubt that the death of the deceased was approximately caused by the criminal conduct of the defendant. The proximate cause of death is that cause which, in natural and continuous sequence, unbroken by any independent intervening cause, produces death without which the death would not have occurred. The defendant's conduct need not be the sole or immediate cause of death. The acts or omissions of two or more persons may work concurrently to proximately cause the death. And in such a case, each of the participating acts or omissions is regarded as a proximate cause. It is not a defense that the negligent conduct of the deceased may also have been a proximate cause of the death. However, it is a defense to homicide if the proof shows that the death was caused by an independent intervening act or omission of the deceased, or another which the defendant, in the exercise of ordinary care, could not reasonably have anticipated is likely to happen. However, if, in the exercise of ordinary care, the defendant should reasonably have anticipated the intervening cause, that cause does not supersede the defendant's original conduct, and the defendant's conduct is considered the proximate cause of the death. It is not necessary that the sequence of events or the particular injury be foreseeable. It's only necessary that the death followed in the general field of danger, which the defendant should have reasonably anticipated. If some other circumstance caused the victim's death, unrelated to the defendant's actions, that would be a defense to homicide, unless the circumstance was the natural result of the defendant's act. If you find that the defendant's acts, if any, did not unlawfully cause or contribute to the death of the deceased, or if you have a reasonable doubt as to this proposition, you must find him not guilty. The court charges you that the identity of the defendant must be proven in the case on the part of the state to your satisfaction beyond a reasonable doubt. In other words, the burden of proof is on the state to show that the defendant now on trial before you is the identical person who committed the charge or an included offense. In considering the identity of a person, the jury may take into consideration all the facts and circumstances in the case. The court further charges you that if from the whole proof in the case you are satisfied beyond a reasonable doubt that the defendant committed the charge or an included offense, and you are satisfied beyond a reasonable doubt that he has been identified as the person who committed the charge or included offense, then it would be your duty to convict him. On the other hand, if you are not satisfied with the identity of the proof, or if you have a reasonable doubt as to whether he has been identified from the whole body of proof in the case, you should return a verdict of not guilty. The guilt of the defendant, as well as any fact required to be proved, may be established by direct evidence, by circumstantial evidence, or by both combined. Direct evidence is defined as evidence which proves the existence of the fact at issue without inference or presumption. Direct evidence may consist of testimony of a person who has perceived by the means of his or her senses the existence of a fact sought to be proved or disproved. Circumstantial evidence consists of proof of collateral facts and circumstances which do not directly prove the fact at issue, but from which that fact may be logically inferred. It is your duty to decide how much weight to give the direct and circumstantial evidence. The law makes no distinction between the weight that you should give to either one, or say that one is any better evidence than the other. You should consider all the evidence, both direct and circumstantial, and give it whatever weight you believe it deserves. It is your job to decide what the facts of this case are. You must decide which witnesses you believe, how important you think their testimony is. You do not have to accept or reject everything a witness said. deciding which testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules for judging whether you believe a witness. It may help you to think about these questions. 1. Was the witness able to see or hear clearly? How long was the witness watching or listening? Is anything else going on that might have distracted the witness? 2. Did the witness seem to have a good memory? 3. How did the witness look and act while testifying? Did the witness seem to be making an honest effort to tell the truth? Did the witness seem to evade the questions? 4. Has there been any evidence presented regarding the witness's intelligence, respectability, or reputation for truthfulness? 5. Does the witness have any bias, prejudice, or personal interest in how the case is decided? 6. Have there been any promises?
Well, I don't believe a word that
suggestions, or
Johnny
other
Lawrence
influences that
said.
affected how the
I
witness
think he was
testified?
making half of that up
7.
on the spot.
In general, does the witness have any special reason to
I
tell
don't
the
know why,
truth or any special reason to lie?
but it did not sound
8. All in all, how reasonable does the witness's
sensible.
testimony seem when you think about all the
I don't know any other way to explain it.
Sometimes the testimony of different witnesses will not agree, and you must decide which testimony you accept. You should think about whether the disagreement involves something important or not, and whether you think someone is lying or simply mistaken. People see and hear things differently, and witnesses may testify honestly, simply be wrong about what they thought they saw or remembered. It's also a good idea to think about which testimony agrees best with the other evidence in the case. You may conclude, however, that a witness deliberately lied about something that's important to how you decide the case. If so, you may choose not to accept anything that witness said. On the other hand, if you think the witness lied about some things but told the truth about others, you may simply accept the part you think is true and ignore the rest. The testimony of a witness may be discredited or impeached by careful cross-examination involving the witness in contradictory, unreasonable, and improbable statements. However, immaterial discrepancies or differences in the statements of witnesses do not affect their credibility unless it should plainly appear that some witness has willfully testified falsely. The testimony of a witness may also be impeached by proving that he or she has made a prior inconsistent statement, that is, a material statement that he or she made out of court that is at variance with his or her testimony on the witness stand. However, the earlier statement is brought to your attention for the sole purpose of discrediting or casting doubt on the accuracy of the witness's present testimony here at the trial. You may not use the witness's earlier statement as proof that something said in it is true. When the testimony of a witness is impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony from other facts and circumstances proved on the trial. During the trial, you heard expert testimony. The rules of evidence provide that if scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact of issue, a witness qualified as an expert by reason of special knowledge, skill, or experience may testify and state his or her opinions concerning such matters and give reasons for his or her testimony. Merely because an expert witness has expressed an opinion does not mean, however, that you are bound to accept this opinion. The same as with any other witness, it's up to you to decide whether you believe this testimony and choose to rely upon it. Part of that decision will depend on your judgment about whether the witness's background or training and experience is sufficient for the witness to give the expert opinion that you heard. You must also decide whether the witness's opinions were based on sound reasons, judgment, and information. You are to give the testimony of an expert witness such weight and value as you think it deserves, along with all the other evidence in the case. Court instructs you that while there is evidence of an oral or written statement given by the defendant in this case, you may take it into consideration with all the other facts and circumstances proven in the case. While this evidence has been received, it remains your duty to decide if in fact such statement was ever made. If you believe a statement was not made by the defendant, you should not consider it. If you decide the statement was made by the defendant, you must judge the truth of the facts stated. In so determining, consider the circumstances under which the statement was made. Also consider whether any of the other evidence before you tends to contradict the statement in whole or in part. You must not, however, arbitrarily disregard any part of any statement, but rather should consider all of any statement you believe was made and is true. You are the sole judge of what weight should be given such statement. If you decide a statement was made, you should consider with all the other evidence in the case in determining the defendant's guilt or innocence. If from the proof you find that the defendant has committed acts other than those for which he is on trial, you may not consider such evidence to prove his disposition to commit crimes such as those for which he is on trial. This evidence may only be considered by you for the limited purpose of determining whether it provides, 1, the complete story of the crime. That is, such evidence may be considered by you where the prior acts and the present alleged crime are logically related or connected or are part of the same transaction, so that proof of the other tends or is necessary to prove the one charged or is necessary for a complete account thereof. 2, a scheme or plan. That is, such evidence may be considered by you if it tends to establish that the defendant engaged in a common scheme or plan for the commission of 2 or more crimes so related to each other that proof of one tends to establish the other. 3, the defendant's intent. That is, such evidence may be considered by you if it tends to establish that the defendant actually intended to commit the crime with which he is presently charged. Guilty knowledge. That is, such evidence may be considered by you where guilty knowledge is an essential element of the crime charge, and evidence of the other acts tend to establish that the defendant possessed this knowledge at the time of the commission of the crime presently charged. Such evidence of other acts, if considered by you for any purpose, must not be considered for any purpose other than that specifically stated. The state has a duty to gather, preserve, and produce at trial evidence that may possess exculpatory value. Such evidence must be of such a nature that the defendant would be unable to obtain comparable evidence through reasonably available means. The state has no duty to gather or indefinitely preserve evidence considered by a qualified person to have no exculpatory value, so that as yet unknown defendant may later examine the evidence. If, after considering all the proof, you find that the state failed to gather or preserve evidence, the contents or qualities of which are at issue, and the production of which would more probably than not be of benefit to the defendant, you may infer that the absent evidence would be favorable to the defendant. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proved beyond a reasonable doubt that the defendant fled is a question of your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be a hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving of the scene of difficulty and a subsequent hiding out, evasion, or concealment in the community, or a leaving of the community for parts known to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight, if flight is so proven, together with all the other evidence when you decide the guilt or innocence On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by the facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Any attempt by a person to conceal evidence is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Whether the evidence presented proves beyond a reasonable doubt that the defendant concealed evidence is a question for your determination. If this fact is proven, it alone does not allow you to find the defendant is guilty of the crime alleged. A person entirely innocent of a particular crime may attempt to conceal evidence, and the concealment may be explained by proof offered or by the facts and circumstances of the case. However, because an attempt by a defendant to conceal evidence may be caused by a consciousness of guilt, you may consider this fact, if it is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. It is for you to determine whether there was any attempt to conceal evidence by the defendant, the reasons for it, and the weight to be given. The court has charged the jury concerning an inference the jury may make in regard to certain evidence in this case. However, the jury is not required to make this inference. It is the exclusive province of the jury to determine whether the facts and circumstances shown by all the evidence in the case warrant the inference which the law permits the jury to draw. The inference may be rebutted by direct or circumstantial evidence, or both, whether it exists in the evidence of the state or is offered by the defendant. Although the defendant is not required by law to
I
do so,
know.
when the defendant offers
Long and
explanation
boring.
about the phrase, you should consider such explanations along with all the evidence to determine not only the correctness of the inference, also to the reasonableness of the defendant's explanation. You are not bound to accept either the inference or the defendant's explanation. The statement of the offense before the defendant can be found guilty. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take a stand in his own behalf. His election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. During your deliberations, you must not communicate with or provide any information to anyone about this case by any means outside the jury deliberation room. You may not use any electronic device or media, such as a telephone, cell phone, smartphone, iPhone, computer, the internet, any internet service, or any text or instant messaging service, or any internet chat room, blog, or website, including but not limited to Facebook, LinkedIn, YouTube, Snapchat, Instagram, Google, Twitter, or any other social media to communicate to anyone any information about this case, or to conduct any research about this case until you have returned your verdict and the trial has concluded. During this trial, you have been permitted to take notes for your own use during your deliberations. The notes you may have taken should not be considered to be a transcript of the testimony. As such, once you retire to the jury room, you may refer to your notes, but only to refresh your own memory. You may not read from your notes to your fellow jurors or otherwise inform them of what you have written. The notes may contain errors. They may be understood or taken out of context, since they could only pertain to part of the testimony and are not an exact account of what was said by the witness. You are free to discuss the testimony of the witnesses.
Your memory can be just as wrong as your notes.
Allow his or her own memory as to what the witness did or did not say. Upon conclusion of your deliberations, the court will collect and destroy all of the notes taken by any juror.
More likely that your notes
Count
are
one of the
more
presented
accurate than your
offenses,
memory.
In addition to the charged offense, one or more lesser offenses. offenses are listed in order from greatest to least. In reaching your verdict on count one of the presentment, you shall first consider the offense charged in the count. If you unanimously find the defendant guilty of the charged offense beyond a reasonable doubt, you shall return a verdict of guilty for the charged offense. If you unanimously find the defendant not guilty of the charged offense, or have a reasonable doubt of the defendant's guilt of the charged offense, you shall then proceed to consider whether or not the defendant is guilty of the next listed offense. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or if you unanimously have a reasonable doubt the defendant's guilt of the immediately preceding greater offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in count one, you shall return a verdict of not guilty on that count. The crime charged in each count of the presentment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty on one or both counts. Your finding as to each count must be stated in your verdict. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so while respecting individual judgment. Each of you must decide the case for yourself. Do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. Do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations, ensure that they're conducted in a business-like way, and everyone has a fair chance to be heard. When you have reached a verdict, you will return with it to this courtroom, and your foreperson will deliver the verdict form to the court. If you find that the state has proven the defendant guilty beyond a reasonable doubt, then you should find him guilty. If, however, you find that the state has not proven the defendant's guilty beyond a reasonable doubt, or if you have a reasonable doubt as to the defendant's guilty, you must find him not guilty. You will be provided with forms of all possible verdicts in this case. The jury will complete the forms, and your foreperson will sign and date them. The verdict forms that you will receive read as follows. With respect to count one, presentment 315228, we, the jury, find the defendant, Jason Chen, please mark one of the following verdicts: guilty of first-degree murder, guilty of first-degree premeditated murder, or guilty of second-degree murder, or guilty of voluntary manslaughter, or guilty of aggravated assault, or guilty of reckless homicide, or guilty of reckless aggravated assault, or guilty of criminally negligent homicide, or guilty of assault, or guilty of reckless endangerment, or not guilty.
He's got a bunch of lesser includeds.
With respect to count two of presentment 315228, we, the jury, find the defendant, Jason Chen, please mark one of the following verdicts: guilty of abuse of a corpse, or not guilty. Members of the jury, you have heard and seen all the evidence in the case. After lunch, parties will have the opportunity to present their closing arguments. Under the rules of criminal procedure, the state will argue first, and the defendant will have an opportunity to present his closing argument. The state may then, if it chooses, argue in response or in rebuttal to the defendant's argument. Closing arguments are designed to present to you the party's theories about what the evidence has shown and what conclusion may be drawn from the evidence. Remember, court has said in closing arguments is not evidence. We've already heard and seen all the evidence in this case that we may properly consider. During their closing arguments, the parties may mention points of law or refer to these instructions that the court has given you. However, the law that you must follow in reaching your verdict is the law that the court has given to you in its final instructions. If there's any difference between what the parties say about the law and what this court has said in its final instructions, you must follow the court's instructions. Ladies and gentlemen, those instructions, it is 12:20. Terry, can you break it along with? Yes, sir.
Did he say what time to be back?
We're going off campus, so we're gonna take an hour and a half lunch. So we're determined to have lunch. Be prepared for the arguments will probably lengthy. It's 12:20, so the parties and jury be back here at 10 minutes to 2.
Oh.
Any of the parties to bring up before we take our lunch recess?
After the reading of the jury instructions, it's not so much an objection, it's just a question for it. Do you perceive there to be an issue with the use of court's instructions? Because, well, first off, I'm not sure if that's a continuing offense, but if it's not a continuing offense, then the state would be required to make a section of offenses. So, I've never encountered that situation before. I've researched this slightly. I don't know.
Please, you see this. Basically, the state has alleged a series of use of force, one that treated in a manner that offended the sensibilities of an ordinary person, and two, that it was in violation of a law.
If he's found guilty of that offense, we won't know which one.
Can we get a response to that?
No, Your Honor, I'm actually not sure under this statute whether election is required. If the court wants to play it safe and require that the jury pick one or the other, maybe that's the safest route to go, but I haven't looked
Get
up.
out of the car.
The jury instruction says or. So we can research it, but I'm also for appellate review purposes, fine with requiring the jury to choose which one.
I do know that we've given it to juries, like aggravated burglary cases, for example, felony theft or assault is an indictment that's been found to be fine. I don't think there's no problem so far. To be safe, I may add in that final form, your use of a corpse, one or two theories, we'll have to check one or the other.
You could do that. It also makes me think of aggravated assault. We are not required to elect under which category of aggravated assault. So I'm not sure if it's analogous or not, but we're not required to elect. It can
Fine
either.
so far, just whether or not
Sure.
the jury instruction should be tweaked.
Aggravated assault, I think, is a continuing offense. I don't know if the use of force is, and I guess it could be, but I'm not sure.
Based on the littering component of it, of course, I think it lends itself to the fact it might be. Right? The litters.
I have never considered the issue.
Okay, let's do this then. Do one more thing I get to look at over lunch. You guys enjoy lunch. I'll get ready for your closing, I should say, and I'll let you know what I find.
Thank you, Judge.
Thank you. All right, we'll recess till 1:50.
Okay, guys, I will see you back at 1:50. Yeah, that's a lot of ors. That was a lot of lesser includeds. Okay, closing statements at 1:50. See you guys then. Bye.